All right. Donald Trump thought he was untouchable. 30 years of courtroom battles, 4 criminal indictments, a civil fraud verdict that shook Wall Street. And he walked through every single one of them like a man who genuinely believed the rules were written for someone else. Right now, a court just dropped a command so unexpected, so surgical, so precisely targeted at the one thing Trump cannot spin or fundraise his way out of that his own lawyers went silent for 30 seconds when they read it. The properties, the finances, the personal exposure, all of it cracked open at once. What happened between the man who declared himself untouchable and the judge who just proved otherwise is the story the loudest voices on every side are too afraid to tell straight. Because this isn't about politics. This isn't about which team you're on. This is about a court that looked at years of maneuvering, years of delay, years of every exit being taken the moment consequences got close, and said 4 words that should terrify anyone who thought this was over. We anticipated all of it. That's what they said. And when you understand what the court commanded next, you'll realize why Trump's reaction wasn't rage. It was something far more telling than rage. So what pushed this ruling over the edge? One document, one pattern the monitor uncovered. One thread that, when pulled, unraveled something Trump had spent years carefully keeping in the shadows. But here's what nobody's telling you. This didn't come from prosecutors. This didn't come from political opponents. This came from inside the Trump organization's own records, handed to a court-appointed monitor who was put there by a judge who knew exactly what he would find, and I'm going to show you precisely how it all came apart. See, most people think this ruling came out of nowhere. It didn't. It started with the original fraud verdict, with the monitor, with a quiet infrastructure of legal oversight that has been tightening around Trump's finances, one document at a time, for over a year. That's not a sudden attack. That's not political theater. That's a mechanism that was built specifically for a defendant who had spent 4 decades proving that ordinary legal consequences were not going to reach him. And the moment the court decided ordinary wasn't going to work anymore is the moment everything you're about to hear became inevitable. Let's start where most coverage refuses to start, at the beginning of the pattern. Not February, not 2023, not even the lawsuit. The beginning goes back further than anyone wants to admit, back to a fundamental belief that Donald Trump carried with him through 4 decades of boardrooms and bankruptcies and billion-dollar deals. The belief that consequences were for other people. You could trace it back to the 1980s if you wanted to. The Atlantic City casinos, the airline, the mortgage company, the steak business, the university. Each collapse came with creditors left holding losses. Contractors who didn't get paid, investors who watched returns evaporate. And after every single one, Trump emerged, shaken sometimes, bloodied occasionally, but still standing. The pattern wasn't invisible. Journalists wrote about it, biographers documented it, former business partners complained about it publicly in interviews that got 5 minutes of coverage and then disappeared. The banks that lost money kept lending because the brand was worth something. The lawyers that settled cases kept getting paid because there was always another deal. The accountants that signed documents kept signing because the client was famous and the fees were real. That's the ecosystem that produced this moment. Decades of a system designed to absorb Trump's rule bending without ever producing a reckoning, until someone decided to produce the reckoning themselves. Here's what most people still don't fully understand about the legal architecture that made this latest ruling possible. The foundation was already laid. The earlier civil fraud case, the $355 million penalty, the independent monitor, the business dissolution orders, all of that created something that hadn't existed before in Trump's legal history. A framework with real teeth, a structure where defiance had a cost, a system where the man who spent 40 years believing he could outmaneuver any judge, any prosecutor, any opposing counsel was suddenly operating inside boundaries he didn't build and couldn't charm his way out of. The independent monitor placed over Trump Organization operations wasn't symbolic, it was surgical. Every major financial decision routed through court-appointed oversight, every significant business move subject to review by someone with no loyalty to the brand, no history with the family, no reason to look the other way when something didn't add up. That monitor started finding things almost immediately. Not dramatic things, not crime novel things, quiet things, discrepancies between what the Trump organization was representing to various parties and what the underlying documents actually showed, patterns in how decisions were being made, questions about whether certain asset movements that happened after the original fraud ruling were genuinely routine or whether they represented something more deliberate. Those questions made their way back to the court. And that's when the judge decided he needed to issue the ruling that nobody saw coming. The command itself, when it finally landed, was 3 parts. And each part was more significant than the last. The first part was an expanded monitoring order. Not content with the original oversight structure, the judge widened the scope of what the court-appointed monitor had authority to review, asset transfers going back further than the original case timeline, financial arrangements involving entities that hadn't been part of the earlier proceedings, deals that were structured in ways that raised questions about whether Trump was attempting to insulate certain holdings from potential judgment enforcement. Legal analysts who read the expanded order carefully noted something important. The judge wasn't just protecting the existing judgment, he was anticipating future ones. He was constructing a legal cage that would be significantly harder to escape if subsequent proceedings produced additional liability. That's not a judge wrapping up a case. That's a judge preparing for a war. The second part of the order was the one that hit hardest. A requirement that Trump himself, not his lawyers, not his organization's CFO, not a designated representative, but Donald J. Trump personally attest under penalty of perjury that he had disclosed all assets, all financial arrangements, all business entities with which he had any connection, direct or indirect, to the court's satisfaction, personal attestation, under oath, with criminal perjury exposure attached. For a man whose entire legal strategy had been built around having layers of representatives and entities between himself and direct accountability, this was a structural attack on the method itself. The judge wasn't just going after Trump's money, he was going after Trump's armor. The third part was the most quietly devastating, a referral. The judge formally referred specific elements of what the monitor had uncovered to the New York Attorney General's office and to federal prosecutors, noting that certain patterns of behavior uncovered during the monitoring process potentially constituted conduct beyond the scope of the original civil case. Civil fraud is serious. Federal criminal referrals are different. Entirely different universe of consequences. Entirely different set of teeth. And the judge put it in writing. Trump found out through his lawyers. That's how it always works with rulings. His lead attorney called, walked him through the order, explained what each section meant. Sources close to the situation say the call was quiet, unusually quiet. Trump asked specific questions which by itself surprised people who expected rage. He asked about the timeline for the perjury attestation requirement. He asked about the scope of the federal referral. He asked about whether the monitor's expanded authority could be challenged in the appeals process and how long that challenge would take. Those aren't the questions of someone performing outrage. Those are the questions of someone calculating. The public statement that came later, the social media post, the campaign rally reference, all of that followed the pattern everyone knows. Witch hunt, political persecution, corrupt judges. The vocabulary hasn't changed in 3 years. The audience responds to it, the donations flow, the base hardens, but privately, according to people who've been in rooms with Trump during previous legal crises and in rooms with Trump during this one, something is different this time. The calculation behind the performance has changed. There's an awareness that the usual delay, attack, and survive strategy is running into a different kind of obstacle. This judge has read every filing. This monitor has reviewed thousands of pages of internal documents. This attorney general has been building the evidentiary record for years. The playbook that worked in civil litigation in the 1990s, that worked in business disputes in the 2000s, that worked in early phases of these very proceedings, that playbook is encountering a courtroom that anticipated it. And Trump's lawyers know it. You can hear it in the phrasing of their public statements. Less confident than before, more careful, more hedged. The word egregious has stopped appearing in their arguments because they learned what happened the last time someone used it in this case. The judge used it right back at them with interest. Now let's talk about what the reaction actually looked like beyond the official statement. Because the official statement is what Trump wanted you to see. What happened around it tells the more important story. Within hours of the ruling becoming public, 3 things happened simultaneously that you need to understand as a picture rather than separate events. Trump's campaign sent out an emergency fundraising email. The subject line called the ruling an unprecedented attack on American freedom. The donation link appeared 6 sentences in. By the end of the day, the email had reportedly generated millions in small dollar contributions. This is the financial architecture of Trump's legal strategy. Every loss becomes a fundraising mechanism. Every ruling becomes proof of persecution that motivates the base to open their wallets. It's a feedback loop that is genuinely unprecedented in American political history, and it works every single time. Simultaneously, Trump's social media accounts went into overdrive. Not just Trump himself, but the network of allied accounts that amplify his messages started saturating platforms with content about judicial bias, about weaponized prosecution, about the deep state using courts as weapons. The volume was deliberate. The goal wasn't persuasion. The goal was saturation. Flood the information environment so thoroughly that even people who don't believe the narrative are fatigued by it. And at the same time, quietly, away from cameras, Trump's legal team filed a motion to stay the expanded monitoring order pending appeal. They argued it was overbroad. They argued it violated separation of concerns between civil and criminal proceedings. They argued the personal attestation requirement was designed to create perjury exposure rather than to gather genuinely needed information. 3 tracks running simultaneously. Public outrage for the base, legal maneuvering for the courtroom, fundraising for the war chest. This is what sophisticated crisis management looks like. And credit where it's due. Trump's team has gotten remarkably good at running all 3 tracks without letting any of them interfere with the others. But here's the problem they're running into. The judge anticipated the stay motion too. Embedded in the original ruling was language that specifically addressed the standard for stays in cases involving ongoing monitoring of potential asset concealment. Language that legal analysts noted had no accidental quality. Every word was placed to make the stay harder to grant. This isn't a judge who is reacting to Trump. This is a judge who is 3 moves ahead of him. Let's talk about the federal referral piece, because this is where the story stops being about real estate valuations and starts being about something with no ceiling. When a civil court judge refers matters to federal prosecutors, that referral is not a suggestion. It's not a recommendation. It's a formal transmission of documented evidence with a request that federal authorities evaluate whether criminal statutes have been violated. Federal prosecutors are not obligated to act on such referrals, but they are obligated to review them. And they are very much aware that ignoring a referral from a sitting judge in a high-profile case that is being watched by every legal scholar in the country is not a cost-free decision. The specific elements that were referred are not fully public. The order references them obliquely, using the careful language of a judge who knows everything he writes will be scrutinized by appellate courts and legal historians alike. But reading between the lines, 2 categories of behavior appear to be central. The first is the question of asset movement after the original fraud ruling. Were assets transferred, restructured, or repositioned in ways that were designed to put them beyond the reach of judgment enforcement? If so, that's not just contempt of court. That potentially constitutes obstruction of civil proceedings, which has federal criminal implications. And if it was done with the knowledge that such transfers would interfere with enforcement, intent can be established. The second is the ongoing accuracy or inaccuracy of financial representations being made by the Trump Organization to third parties during the period of court monitoring. If the monitor found evidence that financial statements being submitted to banks, to insurance companies, to business partners continued to contain material misrepresentations, even after the original fraud finding, that's a continuation of the conduct that created liability in the first place. And a continuation with full knowledge of the original finding is not an accident, it's a choice. Federal prosecutors tend to find such choices interesting. Neither category has produced an indictment. Neither category has produced a federal charge. But both categories are now in the hands of people who carry badges and who do not have to file campaign finance reports and who are not running for any office that requires winning any election. That changes the dynamic in ways that Trump's usual playbook has no answer for. The legal community's response to this ruling has been split along a line that is more intellectually interesting than the political split everyone focuses on. On one side, you have legal scholars who argue that Engoron's approach, now extended through this new order, represents a genuinely dangerous expansion of judicial power. The concern isn't about Trump specifically. It's about the tool itself, a judge who can issue expanded monitoring orders compel personal attestations, and generate federal referrals based on information gathered by a court-appointed monitor is a judge exercising a level of ongoing supervisory power over a private business that the legal system was not traditionally designed to sustain. If this becomes the model for how courts handle complex financial fraud cases involving large organizations, the implications for every major business entity in America are significant. This argument deserves to be taken seriously. Not because it lets Trump off the hook, but because legal tools don't come with political labels. What a judge can do to one prominent business figure, a judge can do to another. The precedent doesn't care about party registration. On the other side, you have practitioners who've spent careers watching financial fraud go unanswered because the traditional tools of civil litigation were never calibrated for defendants who have infinite resources, infinite patience, and a demonstrated willingness to use every procedural mechanism available to delay, exhaust, and outlast the legal process. These attorneys argue that Engoron's approach is precisely what the system needed because traditional approaches had failed repeatedly against exactly this profile of defendant. Both sides are making real arguments, and both sides are aware that the appellate courts are going to have to choose between them. The stakes of that choice extend far beyond this one case. Asset evaluators have been studying Trump properties in detail, not casually, in detail. Revenue streams, debt structures, lease arrangements, property conditions, maintenance records, everything that determines real market value rather than aspirational brand value. The gap between those two numbers for Trump properties tends to be significant. James's office knows exactly how significant. She has also, according to sources familiar with the proceedings, been in communication with potential buyers, not formal discussions, not anything that could be characterized as prejudging an outcome that hasn't been finalized, but awareness-building conversations, making sure that if the enforcement machinery needs to run, there are interested parties ready to engage quickly, rather than letting properties sit in legal limbo for years while Trump's team runs out the clock. This is what sophisticated prosecutorial preparation looks like. The symbol that defined his brand sits at the top of that list. The irony is almost too much to process. The man who put his name in gold letters on the most famous tower in Manhattan as a declaration of permanent dominance might watch that tower's ownership change hands because of documents filed inside it that claimed it was worth 3 times its actual value. Sometimes the symbolism writes itself. The people who are genuinely caught in the middle of this, and they exist and they matter even though they rarely appear in coverage, are the thousands of employees whose livelihoods are tied to the functioning of Trump Organization properties. The doormen and building staff who show up every morning to buildings that are now under court supervision. The maintenance workers and contractors whose payment cycles are subject to monitor review. The vendors and suppliers who have outstanding invoices and uncertain timelines for resolution. The managers who are making operational decisions inside a business where every significant choice gets routed through an independent oversight process that wasn't there 2 years ago. These are not abstract people. These are families. And they are experiencing a version of this story that is entirely different from the version experienced in courtrooms and on social media and in legal briefs. Their version is uncertainty. Their version is wondering whether the organization they work for will look the same in 6 months. Their version is watching their workplace become a political battleground while they just need to know if their health insurance is going to stay intact. Nobody's fundraising off their anxiety. Nobody's using it as a campaign rallying cry, but it's real. And it's one of the human costs that gets lost in the noise of everything else. Here's what the next 60 days look like. And I want to be precise about this, because the timeline is tight and the consequences of what happens in it are enormous. The appeals court is moving. Oral arguments have been scheduled. The judges in that room are going to ask hard questions of both sides. They are going to probe the limits of the monitoring order. They are going to question whether the personal attestation requirement creates constitutional problems. They are going to explore the boundaries of what civil courts can do in fraud cases and whether Engoron's approach, aggressive and unprecedented as it is, stays within those boundaries. Nobody knows which way they lean. Court watchers who read the appellate bench closely say the signals are genuinely mixed. There are judges on that panel who have historically been skeptical of expansive judicial power in civil proceedings. There are also judges on that panel who have built records of taking financial fraud seriously and deferring to trial courts that have spent months immersed in complex evidence. The combination of who's asking which questions during oral arguments will tell experienced observers a great deal. The ruling that follows will tell everyone. Meanwhile, the federal referral is sitting in prosecutors' offices. It doesn't expire. It doesn't lose relevance if the civil case gets modified on appeal. If anything, an appellate reduction of the civil penalty creates more political space for federal prosecutors to move on the referral without appearing to pile on. The two tracks are semi-independent, and their independence is not Trump's friend. And the personal attestation deadline is coming. Trump's lawyers filed to stay it. That motion will be decided. If the stay is denied, Trump faces a choice that has no comfortable option: attest and expose himself to perjury risk. If the monitor subsequently finds inconsistencies, decline to attest and face contempt consequences that are immediate and serious. Find a way to delay further, which is the option his team always reaches for, but which the judge has repeatedly shown he anticipated. Every door in this structure leads somewhere Trump doesn't want to go. That's not an accident. That's what 300 pages of meticulous preparation by a legal team that has been working this case for years looks like when it's executing. Let me tell you what's really keeping Trump's closest advisors awake at night. Not the money, not even the criminal referral, as serious as that is. The thing that represents the most dangerous threat to everything Trump has built is simpler and more fundamental than any specific legal proceeding. It's the brand. It's the brand. The entire Trump financial empire was built on the premise that the name was worth a premium, that a building with Trump on it was worth more than an equivalent building without it, that the association with wealth and success and victory was itself a financial asset that could be monetized in licensing deals and management contracts and development partnerships worldwide. That premise is under assault in a way that no legal proceeding alone could produce. When 30 insurance companies won't bond you, when banks you've worked with for decades are quietly reducing exposure to your properties, when international partners are renegotiating licensing deals over concerns about reputational risk, the premium is eroding, not disappearing overnight. Erosion, slow and cumulative and very hard to reverse. A name that commanded premiums because it represented success starts commanding discounts when it becomes associated with protracted legal defeat. Not with prosecution, which the base has been conditioned to view as evidence of persecution. With defeat, with the spectacle of a business empire forced into court supervision, forced to operate under a monitor, forced to face attestation requirements and federal referrals and enforcement machinery that has been painstakingly assembled to move quickly when the moment comes. The legal case can be spun as political persecution. The brand erosion cannot. It shows up in numbers that are harder to argue with than court rulings, and somewhere in the quiet calculations that happen far from rally stages and social media posts. The people who have built their financial futures around the continued value of that brand are watching those numbers and asking questions that nobody has answers to yet. There's a question I keep coming back to, one that this ruling, more than any previous one, has brought into focus. What does winning look like for Trump in this situation? Not winning the narrative. Not winning the fundraising battle, not winning the political cycle, winning the actual legal and financial situation that this ruling has created. And the honest answer is that winning in the traditional sense is no longer fully available. Even a favorable appeals court ruling that reduces the penalty substantially doesn't undo the monitor, doesn't undo the federal referral, doesn't undo the documentation that has been created about how the Trump organization actually operates, doesn't restore the relationships with financial institutions that have been quietly damaged, doesn't reverse the brand erosion that has been accumulating in premium markets. The best realistic outcome for Trump at this point is damage limitation. Reduce the financial penalty to a number that's painful but survivable, get the monitoring order narrowed to a scope that doesn't compromise every major decision. Well, the panna that they're favorable operative prost-cultural that the baller which to the null of follower dominance and peril, the anbetchte contutemand of bipeel are markedly wanting and selling, well, what thing the while dot increasing publicans variance, or thing we call thing show. What find out ambithen pedig the pikinti is pomo or stirfisik bayarkordi is a mathir R5, the thing wait, where thing way are abdultor is it, where 5 wart barcum so thin solus defense. But they're now way arterial suvel or just show and bolarkiks deportin erin every terrafair. You know, to slow down the federal referral process enough that it becomes a background concern rather than an immediate threat. Maintain enough public narrative control that the base continues to see persecution rather than accountability. That's a defensive strategy. It might work. Trump is genuinely capable of sustaining defensive legal strategies for longer than anyone expects. He's done it before. The resources and the will and the tactical creativity are all real, but it's not the same as winning. And everyone who has been watching this case carefully enough knows the difference, even if they're not saying it out loud. Here's what I need you to understand about why this specific ruling matters beyond the Trump case itself. The template that Engoron has created, expanded by this latest order, represents a new model for how courts handle large-scale financial fraud involving defendants with unlimited resources and proven willingness to weaponize legal process as delay. Expanded monitoring, personal attestation requirements, federal referrals built on monitored evidence, enforcement infrastructure assembled before the final legal outcome rather than after. If this survives appeal, it becomes a precedent. Not just in New York. Across jurisdictions where similar cases exist and where plaintiffs and prosecutors have been frustrated for decades by defendants who could afford to outlast traditional legal mechanisms. That's not a comfortable thought, even for people who believe Trump deserves every consequence he faces. Because the precedent doesn't come with a label that says for use only against people you think are guilty. It comes with legal availability to anyone who can establish the factual predicate and convince a judge that traditional tools are insufficient. The tool is powerful. The question of who wields it next is the question nobody in legal academia can answer. And that uncertainty, more than any specific ruling in this case, is what serious legal thinkers are wrestling with when they go home at night and sit with this for the first time away from the cameras and the commentary. So where does this end? I don't have that answer. Nobody does. What I have is this. A judge who has spent years watching a man operate outside the rules has constructed a legal framework designed to close every exit. A prosecutor who campaigned on accountability has assembled enforcement machinery that is ready to move the moment conditions allow. A federal referral sitting in prosecutorial hands with no expiration date. A personal attestation requirement that creates inescapable exposure in one direction or another. An appeals court preparing to make a decision that will echo through American jurisprudence for decades. And in the middle of all of it, a man who built his empire on the belief that consequences were for other people, now facing a system that has spent 3 years specifically building the case that this time they are for him. The ruling has been issued, the reaction has been cataloged, the machinery is in motion. What happens next will not be quiet. It will not be small. And it will not leave the country where it found it. The clock is moving. The deadline is coming. And everyone involved knows that what breaks in the next 30 days will determine not just one man's financial future, but the shape of accountability in America for a generation. Watch closely. Because when this moves, it moves fast. And the full weight of what's been built here will land all at once on a story that isn't finished being written yet. Trust me on this one. You don't want to look away.